Before anything else, if you are in immediate danger, call 911. If you need support or want to talk through your options, the National Domestic Violence Hotline is available at 1-800-799-7233, anytime, day or night. What follows is general information about a California court form, not a substitute for that kind of help. Form DV-109 tells both sides in a California domestic violence case when and where the court hearing is. Here is who completes it, who serves it, and how it connects to DV-100 and DV-110. What is Form DV-109? Form DV-109 is the notice that tells a restrained person and the protected person when and where the hearing will take place in a domestic violence restraining order case. It is filed together with Form DV-100, the request that starts the case, and it commonly accompanies Form DV-110, the temporary order a judge can sign while the case is pending. There is no filing fee for a domestic violence restraining order case in California, and that includes DV-109 and the other forms filed to start and schedule it. Who completes DV-109? The person asking for protection, generally called the petitioner, fills in only two things on DV-109: their own name, Item 1, and the name of the person they are asking the court to restrain, Item 2. Everything else on the form, including the hearing date, time, department, courtroom, and whether a temporary restraining order was granted, is completed by the court clerk after the case is filed. It can be tempting to fill in the hearing details yourself, especially if you feel anxious to get the case moving, but the sections reserved for the court should stay blank until the clerk completes them. Filling those sections in yourself can create confusion at the clerk's window and slow down your filing. The hearing date. Item 3 on DV-109 is where the clerk records when and where the case will be heard. Once the clerk hands the form back, that is where the information appears. In general, a hearing is set within about 3 weeks of filing, so the case moves relatively quickly once the initial request is submitted. The hearing date matters for both parties. If you are the protected person, it is the date a judge will decide whether to extend your protection into a longer-term order. If you are the restrained person, missing the hearing does not stop the case. How DV-109 relates to DV-100 and DV-110. The three forms work together as a single filing. DV-100, Request for Domestic Violence Restraining Order, is the request itself, where the protected person describes the relationship and the abuse and asks for specific protections. Our guide on how to fill out Form DV-100 walks through that form section by section. DV-109, Notice of Court Hearing, is the form covered in this guide, telling both parties when and where the case will be heard. DV-110, Temporary Restraining Order, CLETS TRO, is the order a judge can sign the same day the DV-100 is filed, putting some protections in place before the hearing. Our guide on how to fill out Form DV-110 covers what it can include and how long it lasts. Serving the restrained person. DV-109, along with DV-100 and any DV-110, must be personally served on the restrained person before the hearing. Personal service means an adult who is not the protected person and not anyone else covered by the order physically hands the restrained person copies of the papers. This is generally done by a process server, the sheriff, or another eligible adult, not by the protected person. The protected person cannot serve the papers themselves. Only someone at least 18 years old who is not a party to the case can serve the papers. Service must generally happen a set number of days before the hearing. What happens at the hearing? At the hearing set on DV-109, both the protected person and the restrained person have the chance to appear, present evidence, and be heard. In general, the judge reviews the DV-100 request, any DV-120 response that was filed, and any temporary order already in place. Both sides can present testimony, documents, messages, or other evidence supporting their position. The judge decides whether to issue a longer-term restraining order, generally lasting up to 5 years and renewable later, deny the request, or make another order. If a longer order is granted, it generally replaces any temporary order that was in effect. If you are the restrained person, if you received DV-109 along with DV-100 and a DV-110, you have the right to attend the hearing and respond. Missing the hearing does not make the case go away, and the date, time, and courtroom for the hearing are listed in Item 3. Because the outcome can affect custody, housing, and firearms rights, many restrained persons speak with an attorney or their court's self-help center before the hearing, even when representing themselves. Common mistakes to avoid: filling in the hearing date or other clerk-only sections yourself before the form is filed, losing track of the date, time, or courtroom listed in Item 3, assuming a missed hearing pauses or cancels the case, waiting until the last minute to arrange service on the restrained person, not bringing a copy of DV-109 to the hearing along with DV-100 and any DV-110. If your case also involves shared children, our Guide on California Child Custody Laws Explained covers how custody and visitation are generally decided in family court, which can run alongside a domestic violence case. For an overview of the full process by county, see the Restraining Orders by County Hub. If keeping track of all of this by hand feels like a lot, that is exactly what Virdix is built for. The wizard at Virdix.co walks you through these same questions in plain language and prepares your DV-109 for you. Virdix is a document preparation service, not a law firm, so this is not legal advice, but it can help make sure your paperwork is complete and consistent from the start.